So everyone, thank you for joining this conversation. I'm Deborah Rohde, head of the Center on the Legal Profession. And to state the obvious, these are interesting times for legal education. In the wake of the recent recession, law schools have been facing rising costs, falling endowments, reduced government assistance, declining applications, and crushing student debt burdens. And this is, I think, a good time to step back, as many commentators are, including a 5-part series in the New York Times, and ask, if not, is legal education in crisis, at least are there some problems in the way that we are currently structuring our methods for training lawyers? And to think about that question with us, we've asked two people who have a lot of experience with training lawyers and leading the profession on a wide range of issues. First, Ralph Baxter, who's chairman and CEO of Orrick, Harrington, and Sutcliffe, a position he's held since 1990. Under Mr. Baxter's leadership, Orrick has expanded, diversified, and extended its geographic reach, transformed the firm from a domestic organization to one of the world's largest and most prominent firms, with more than 1,100 lawyers in 23 offices in the United States, Europe, and Asia. He's also launched several transformative initiatives that have more closely aligned Orrick with its clients, including the firm's new talent and pricing models, which distinguish it as a really innovative player in the legal industry. He's been recognized as one of America's 100 most influential lawyers by the National Law Journal. He speaks frequently on leadership issues in the legal profession, and in his non-existent free time, he serves on the advisory board for the Legal Profession Center here, for which we are extremely grateful. Michael Holston, who also has made time for service on that board, has until recently been the executive vice president and general counsel for Hewlett-Packard, responsible for the company's worldwide legal affairs, including patents and licenses, litigation, and regulatory matters. And he also oversaw the company's compliance, government affairs, privacy, and ethics operations. Under Michael's leadership, HP became one of the first major companies to hire directly from law school campuses. It had previously hired only lawyers with 5 to 7 years of experience, but in 2009 began to recruit directly from law schools and cross-train its recent grads in conjunction with some of its outside law firms. Before joining HP, Michael was a partner in the litigation practice in Morgan Lewis, where, among other things, he supported HP as an external counsel on a variety of matters for a decade. And before that, he was in the criminal division of the U.S. Attorney's Office for the Eastern District of Pennsylvania. And of course, there is our own very own Larry Kramer, who I'm sure needs no introduction, so he's not going to get one from me. He's just going to start the conversation for us.
Thank you. Also for the no introduction. I hate giving introductions, and I hate getting them even more. Okay, so I think the main reason we're here in a way is something Deborah touched on, which is there has been this cascading avalanche of criticism and concern about what law schools are doing over the last 2 years, and particularly in the last year. The New York Times did this series of articles that got the most attention because, of course, it's the New York Times, but it really just an example of something that's been pretty pervasive in the writings of journalists in every forum that think about law schools. So I'm not going to go through all the criticisms. I assume you guys are mostly familiar with them. In large part, they boil down, though, to essentially the idea that law schools are not adequately preparing students to do what it is they're going to do when they get out of here. And then the complaints about the cost really are tied to that, because it's particularly outrageous to charge people a lot of money when you're not actually preparing them. And then, the variation, which is, law school could or should be 2 years long, or the alternative, which is if it's going to be 3 years, then that third year should just be a clinical year. And that, in some sense, summarizes the vast bulk of what's said. So let me just, since I'm going to try and keep this short so we mostly talk, I'm going to just touch on a couple of points that I hope help set a framework. So first, I want to say a word about jobs and the market, which, of course, is the background to all of this. Most of the criticisms that you read annoy me. right? And they annoy me largely because they're all completely focused on the very, very short term. What happens to graduates now without asking the question, which has to be asked, which is, in terms of investing in a law degree, what are the long-term prospects? How does it pay out over time? The economy goes up and down. There are periods when the economy is down, and when it's down, jobs are obviously harder to get. The question whether, therefore, you should stay away from law school, though, can't be answered simply by that. It really depends on how it'll work. Just very quickly, my anecdote to illustrate this, not to prove, but to illustrate, is my sister went to the 4th best law school in the city of Chicago back in the early 1980s, a very local school, and it was during another recession in the early 80s, and she graduated from law school, and she didn't have a job for her first 2 years. She waited tables at a Bennigan's for a year. But when she found a job, she then had a fantastic career, and if you asked her if it was a mistake, I can tell you the answer is no. Second, there's no comparisons done. So the question also is, what's the alternative to investing in the law degree now and doing that? What happens if instead you do nothing? What happens if instead you go to medical school or psychiatry school or social work school or, God forbid, journalism school? What you're going to go through a 2-year program, take a lot of debt. What are your job prospects when you come out of journalism school, and so on? So I think that all needs to be looked at. Second, with respect to law schools, again, it's important, again, to think about the trends and what's happened. So the legal market grew about 75% between 1985 and 2005. The major law schools actually did not enlarge anywhere near to make up that gap. We enlarged by about 7% as a whole. So the market demand for that was made up by a lot of new entrants into the field, a lot of new law schools. So what you would expect to happen, and of course what will happen, although it doesn't happen right away if the market shrinks, is some of those schools will fail and go out of business. There needs to be an adjustment, and we're in that period of adjustment. And again, people are talking as though, sort of the supply side, the law school supply side, just never changes in response to anything, and there's no reason to think that that's true. Last, just all that said, right, I think we want to separate that from what we do want to talk about here, which is, to the extent that there are schools that are training people to go out and practice law, what should they be doing? Right? And that shouldn't change significantly. We should be doing what we should be doing, in a tight job market or in a very rich one. Next, I just want to note a couple of fallacies in the criticisms themselves and the way it's framed. So there is a lot of talk, and I don't understand this either. The phrase practice ready has suddenly started popping up, and one of the things law school is doing wrong is we're not graduating students who are practice ready. Okay, no professional school in any profession graduates people who are practice ready. Nobody comes out of medical school practice ready. They have an internship, right? And that's true in every single profession, and it's true in ours as well. The difference between the internship in law and the internship in others has been that in the past, weirdly enough, you could get your license to practice at the front end of your internship than at the back end. But of course, almost nobody, particularly in recent years, actually practices. You go into a firm, and that has been, in the same way that going into a hospital has been an internship. Now, whether it's as good an internship is a separate question, and whether law schools can and should be contributing to the quality of the internship is something different. But the notion that in 3 years you're going to send somebody out practice ready for law is just preposterous, and no one should expect or think that. Same thing with the criticism that law schools don't teach practical skills. So this is just a misframing of the debate, in my view. That is, say you're either an intellectual school or you teach, you're a trade school. And of course, no self-respecting school wants to be a trade school. And in truth, we don't need to be trade schools. Those are the skills that really can easily be taught and picked up in actual practice when you're already working for clients. So the question is trying to define the broader set of intellectual and other skills that one needs that we can teach to a comparative advantage inside the law school. And actually, as I'll talk about in a second, I think there's a lot more of that going on, but also a lot more that could be done. Part of the problem with all of the criticism is they're asking the wrong people. I mean, for me, it's very frustrating to read a lot of these articles, and they're talking to lawyers who are talking about what law schools are doing, who, so far as I can tell, are talking about the law school I went to in the 1980s, but they just bear no resemblance at all to any actual law school today. And that runs pretty deep. I mean, they'll be talking to faculty members from different schools who have no idea if I hear one more faculty member talk about, law schools are cash cows for the university, not a single one of them has ever actually looked at a law school budget. The one thing I can guarantee you is there is no law school that is a cash cow for any university. But it runs all the way down. Most of them, they actually have, even our faculty, most of them actually couldn't tell you what our whole curriculum looks like. It's not their job. They don't spend a lot of time looking at all of the different things we're doing. They know their piece of it. and then just make assumptions that it's still kind of the same as it was when they did know, at some earlier point in time. And that's, that's fine. It's just one needs to take it into account. And I would like it if the reporters would talk to people who actually, talk to a curriculum dean who actually puts together the curriculum at a law school. What you would find, and this is the next point I want to touch on, is the face of legal education today, whether good or bad, is very different than what it's being reported as and criticized for being. So, of course, there are still a lot of those old-fashioned, big Socratic courses, right? That is an important part of the education. It's just not all, when I went to law school, it's literally all there was. We had 3 years of that. It's just not remotely what there is today. We think of, and most schools I think are pretty similar in this, you have your core tenure track faculty. They're not the whole faculty anymore, particularly in terms of curriculum offerings. They teach the basic courses, the introductory courses, the courses where you want to show students how to step back and think theoretically and understand the structure of a field. But as students move on in their studies and move into more advanced courses, almost all schools have brought in increasing numbers of thoughtful practitioners who teach courses from their experience in practice. So almost 40 to 45% of our offerings are taught by lecturers today. Similarly, almost every law school has built in an increasing number of skills-oriented courses. Now they are still, not the simple trade skills, but negotiations courses and programs, trial advocacy courses and programs, and if you look through the actual curriculum of most law school, you'll see there's a lot of this, which actually, if you read these newspaper stories, you would think there were none. And of course, clinics have been growing like topsy, although they're not everywhere and they're not pervasive, but they are increasingly a part of the core curriculum everywhere. So, what do we still need to do? As I say, I just want to suggest first that legal education has moved quite a distance from the 1980s version, that is the version that's still getting reflected in the press today. I mean, this won't surprise you. I think what we still need to do is mostly, other schools need to do what we're doing here. And we're not done. That is, say, the directions in which we've started to move here. And, I'll touch on, I think, the three main developments in that respect. So one is to move from a form of education that is focused around teaching problem spotting to a form of education that builds in sophisticated problem-solving skills. Right? That is what lawyers are called upon to do, and it's not what law schools have traditionally done. There are many different ways to do it. Our way to do it, as you know, is to try and integrate and use what's being taught in the rest of the university, where they're training the future clients how to solve their problems, to make that accessible to and part of our students' education. Second, there does need to be more and broader clinical education. Right, we've made one pretty significant move here with the full-time clinic. There are lots of other things to do. We're in the process of beginning a conversation to have a clinical requirement, which I do believe there ought to be. So that needs to be an even larger and more central part of the education. And then third, I actually do think it's very important to do something that we have started also to do here, which is to take the profession side, the public responsibility side of the profession of lawyering, and make that a central part of the education, so that all law schools, so the public interest, is not something reserved for a part of the student body that plans to do full-time careers, but that everybody understands that it is a part of their responsibility as a lawyer, and that includes, helping people to understand what that entails. So it's more than just career choice, and there are skills that are involved. There is curriculum that needs to be developed to enhance that part of the training. Let me lastly just touch on what I think are the broad, that's what we can immediately do within the current framework. We're stuck in a framework because of the bar associations, right? That is to say, they have extensively and excessively regulated legal education. We are way more regulated than any other professional school, and they have basically imposed a really tight straitjacket on all schools. Even when we made the reforms that we made here, we had to find a variety of ways to try and get around ridiculous bar restrictions on every single thing we wanted to do. So they have forced things into that traditional model and made it difficult to move outside. So the first and most important step would be to eliminate the bar associations from any role, as far as I'm concerned, in the regulation of the degree. That's not to say there should be no oversight or regulation. I do believe in accreditation. I just think the bar associations are the wrong people to be doing it. What you need to do fundamentally, and this was actually the one New York Times article that I totally agreed with, right, is the notion that there is one thing called the practice of law that requires one degree, no matter what you're going to do, is just insane. they don't do it anywhere else in the world, we shouldn't do it here. So there ought to be multiple degrees that would take different periods of time. For certain kinds of practice, a year-long degree should suffice. For other kinds, a 2-year degree. For other, a 3, and for others, a 4 or 5-year degree. That would completely readjust the cost model, by the way, which might solve a lot of the problems that exist with respect to that. But it just makes sense. People who want to do a certain kind of thing shouldn't be forced to do a 3-year program, right, if that's not what they need, and to pay for that and all that. And people who want to do certain kinds of things actually ought to probably get more education than we provide. My 5-year program, would move towards then not 5 years of what we do. I think 3 years of the way we're moving it right now here is right. So it would involve, I think there ought to be a 2-year more formalized internship-like program that would obviously involve a partnership between law schools and law firms. For students, that would obviously mean not graduating and getting paid $160,000 right away. So it would be much lower salaries along the lines of what you get as an intern, which means there would have to be loan forgiveness built in because our cost structure is not quite ready to make that adjustment. But there's lots of ways to work this that can bring costs down for everybody and give students much better on-the-job, in-context training as the tail end of an experience that first had a richer intellectual environment. Okay, let me stop there.
Ralph.
Is that the signal you're done?
That's the signal that I'm done.
Well, I'm delighted to be here. You want me to go a second?
No, go right ahead.
I'm delighted to be here. And let me start by making a disclaimer. First of all, I'm not in the business of educating law students, so the observations I'll make, and Mike can speak for himself, are from the sort of consumer of what comes out of law school point of view. I have some thoughts about the issues of educating students who want to become lawyers. I was actually a teacher myself, but it was in the 6th grade in public school, so it doesn't apply much to this. But so I have some thoughts.
Well, you started teaching young.
Yeah, well, no, I mean, yeah, that's right. But let me react, for starters, to a couple of things that Larry has said. And something we talked about a little bit before we started, and that's the idea of preparing students for jobs. My view is that's not quite the right focus. Law is a profession, and we ought to prepare for a profession. And that's one of the reasons some of these issues, such as public responsibility and elements of the responsibility we have as lawyers to our clients, including some financial responsibility to manage what we do in a way that makes sense for them, come into play, because it's a profession, not just a business. And this gets lost in today's world when people think about careers, especially if they're thinking about careers in big law, or if they're thinking about careers in large law departments like Hewlett-Packard. You can begin to lose sight of the fact that we are a profession first and foremost. And integrity and quality and the things that make people want to be professionals as opposed to being just businessmen, and there's nothing, or women, there's nothing wrong with that, or entrepreneurs. It's a different kind of career path. And I think we have to bear that in mind. And of course that relates to the idea that one size doesn't fit all, as you're suggesting. The time it takes to train and be educated to be a lawyer. A career in public service is one thing, a career representing major corporations in toxic waste cases is another, and so on. The second context observation I'd like to make is about economic cycles and the career opportunities that lie ahead for all of you who are students. The current economic difficulties have affected the economy and the businesses of pretty much everybody. They have affected the nature and number of career opportunities, but really there are underlying issues that will continue to change those in the most robust of economies. There will never again be, in my view, as many professional opportunities for law school graduates in settings like big law as there once were, because lots of other changes are underway, driven by the fundamental economics of every business, every client in the world. Changes like one that Mike made at Hewlett-Packard, competing for law students and doing a lot of the work in his law department that previously had been done by outside counsel technology, is changing the nature of the work and doing a lot of the work that early lawyers did, and on and on and on. So I think as you look at a career in law and the training for law, you have to bear in mind that we're never going to go back, I don't think, to the day when you can expect to be paid $200,000 coming out of law school to do reasonably routine things. That's not going to happen. Those things are going to be done by other professionals and by the technology. So now on the subject of educating lawyers, the title of this program was Who Educates the Lawyers? I think it's critical that we understand there really are three answers to that question, and one is law school, what we're going to talk about. The other is the law firm, the law department, wherever it is that you begin your career, and a lot of the learning will happen there and must happen there. And every big law firm in the United States and around the world devotes huge amounts of money and human resources to adding to the education our lawyers have, so that they're educated in a way that will address the issues of the clients. But the third, and maybe the most important participant in all this, is the individual. Education doesn't happen passively. It can't. And so whether it's sitting here in the classroom or whether it was my kids in the 6th grade, the individual is going to drive the outcome as much as any other single factor. And that's why among other things, there's not a perfect correlation between where you went to school and how well you did, because it's about you at the end of the day, and the better the school, the better your chances, but it's really about you. So here are a couple of thoughts about law school education. Number one, I think the role of law schools in preparing lawyers for their professional lives is to immerse them in basically how the law works, how it's made, how you evaluate it, how you construe it, apply it, how you represent people in disputes, but how it works, how the rule of law works, and not about what happens to be the law today. And you need to know a lot of law to understand the structure of it, as Larry said. But really the law will keep changing, and the law you need to know may not even have been written by the time when you start your careers, and the law will constantly change. And part of the role of a lawyer is to be an agent for changing the law when it needs to change, either through the appellate or litigation process or through the lawmaking process. So it's about learning how the law works, and that's easy to say and very complicated, but it's that I think more than anything. On the questions of clinical programs and putting the student in touch with some of these business realities, I think that's a really good idea in an appropriate measure. This would be my perspective. Partly because we're going to need to train new lawyers when they get to Orrick anyway. I think some clinical experience in advising clients or litigating for clients is important, because it puts you in touch conceptually with what it's like to take the classroom learning and apply it. But it's not ever going to substitute for becoming a lawyer, as Larry says. You have to get out there and do it to become a lawyer. I think that's worthwhile. Learning about the business of law, I think that's worthwhile as well. And I think to the extent that law schools can provide students with some education about how you assemble resources and deploy them in the course of practice of law, that would be worthwhile. Again, you're not going to really learn it in a way that's going to make you ready to do it until you get out in the practice of law. But especially if you seek a career in big law or in a big corporate setting, understanding the economic underpinnings of what you do and the economic consequences of what you do is an important part of being a successful lawyer, and really, I think, part of your responsibility as a lawyer, because that's where you have your hands around managing the economic welfare of the client. The client's fundamental welfare that you're protecting is the outcome of the case, the outcome of the advice, but along the way, you're spending a lot of that client's money, or you're trying to if they'll pay the bill. And so I think that is worth us pursuing. I feel a little less strongly about learning about the business of business and learning how to read a financial statement and all of that. I think that would be helpful if you're going to be a corporate lawyer, but it's not that complicated, and I think you can learn that as you go. So I have two final observations just to start this off. One, I do think law school could be, I think Larry's right, of course he is, that how long you need to be in law school depends on what you're planning to be. And of course, most students who come straight through from college to law school don't know yet about what they want to be. But certainly it takes longer to become some kinds of lawyers than others. But I think 3 years as a benchmark is too long. An idea I first got in conversation with Larry, but I think looking back on my experience and what we need to know, 2 years I think really would be long enough. And I think if you could accomplish a 2-year study program, 2 years of law school education combined with an apprentice program, that would be great. And the two great impediments to that are having law firms ready to do it. Howry tried to do it, and that isn't why they failed, but it was probably didn't help. And then the other impediment is the income objectives of the students. And we've created at Orrick a second track. It's not second-class citizen, it's second in sequence. We had a first one, that came first, and we have another one for career associates, people who don't want to be partners in big law. And being a partner in big law is you make a lot of money, but it's hugely intense and time-consuming and so on. So we created a track for students who want to be lawyers doing interesting work, but not have to do all the business that is involved in being a partner. And so far, we're not getting a lot of expression of interest in that from this law school or the Harvard Law School, but we're getting lots of it from other law schools where we're an employer of choice now for career associates. So, but part of the impediment, as Larry says, is are the students willing to go out and take a first job that doesn't pay $200,000 a year in order to learn what you need to learn? Finally, I do think, like every other participant in global commerce, law schools should try to find a way to deliver a legal education for less money. Now, I say that in part because I've got two children who have yet to make it to graduate school of any kind. One is about to. But partly, everybody else is under pressure. Everything's under economic pressure, and we all ought to work to, and I'm sure you are, find a way to deliver legal education for less money.
Thanks, Ralph. So I'm going to adopt his disclaimer because as well, and I'm going to talk maybe a little more about the perspective on the back end. What's the profession look like? What's the career opportunities look like? I have one thing in common with everybody here that the rest of the panel doesn't, which is I'm looking for a job too. I spent, I graduated 25 years ago, and in thinking about getting ready for this program, the thing that's remarkable is how much the legal profession has changed in 25 years. It's staggering, and frankly, at an accelerating pace. I was on the management committee of Morgan Lewis before I joined HP 5 years ago. The last 5 years is probably triple the changes of the 20 years that preceded that. And I don't know all of what it's going to look like 10, 15 years from now, but the change is going to continue to accelerate, not decelerate. In my view. I will say one general thought, which is no one is more self-evaluative or self-critical than lawyers. And law school doesn't have it perfect. But I would echo the point of view. I was with some people and we're just, they're in other professions, and was talking about the fact that I was coming here today. And you talk to people who say, when you graduate, and I had an engineering degree. I was a mechanical and aerospace engineer. What I knew about how to do that when I got out of college, you could have fit on that plate. The notion that someone was going to let me build a spaceship when I got out of college was hopefully not the case. And the same is true when you get out with a medical degree, and the same is true when you get out with a business degree. So it doesn't mean things can't be improved, and the fact that the conversation is happening is the right place to start. And the other thing I will say, having been now at a major corporation, that same self-evaluative process, that same self-criticism is what makes lawyers unbelievably valuable. I had the great good fortune of working for a CEO who thought lawyers are smart people. And when they got the right training, you could get to do a lot of things that had nothing to do with the law, which was one of the things, or not nothing to do, but weren't the practice of law. And that was one of the things that really made that job interesting to me when I decided to go make that change. And I believe that to be true, is that the people who come out of law school are being educated to think a certain way. And when we hire people, I always say we're hiring three things, and depending on what the matter is, you put them in different orders. But basically, in anything, you want judgment, you want experience, and in experience, I mean sort of background in that type of matter, and I would distinguish it from the third, which is expertise. There are certain kinds of things where you just have to have a specific kind of training to go do it. Antitrust law, highly sophisticated environmental law. You just need a certain amount of expertise in that category, and then we're looking for somebody who has that expertise and then has the experience of having done the problem that I'm asking them to do for somebody before. And then ultimately, really, for anything we're asking anyone to do, what's the judgment that they have? And the last thing I'll say before we throw it open is I think it is a very different question of whether you're talking about, and I thought Larry, you had it exactly right, is the focus on what do you want your career to be, or what should the first 2 or 3 years look like? Because it's a very different question. And a lot of what will change in law school is changing because the profession has changed. When I think to what did a law firm get paid to do with its first 3-year associates 25 years ago. That list of items, of things, everybody did the same thing, whether they were in Chicago or San Francisco or New York or Philadelphia. If you were at a big law firm, you did the same thing. And if you were in litigation, you reviewed documents, you attended depositions that weren't important and took notes, and you occasionally got lucky and got to do a small arbitration, do things like that. You look at the list of things that a company like HP will pay a law firm to do. Most of those things we would no longer pay Ralph's firm to do, or any big firm to do, because it can be done through software, because it can be done in India for $20 an hour, because I can bring it in-house and do it, and it's a combination of all of those things. But what's happening is the things that lawyers get paid to do is changing and will continue to change. And I agree that there's cycles, and when the cycle comes back, it will be better than it is today. But we're never going to go back to hiring lawyers on an hourly rate at a big law firm to do the things once it's taken away. Because there may be refinements to how it's done to make it better, but there's never been a view of, you know what, we made a mistake. We should have $200 an hour people reviewing our documents for privilege. That's not the answer. And so that work is going away, and that's changing the model. And then the last thing I'll say is, and ultimately that's going to change. What I think the biggest thing coming is the pricing change that has to happen. Because at HP, the model is built on an hourly rate model. And the reality is there are certain lawyers I will hire for certain matters that I'd be happy to pay them $10 million to get me the right answer. The way they got there was on an hourly structure, and you can only charge so much for one person's hour. So Ralph can't show up and charge me $10,000, an hour, nobody will pay it. But I want him to solve my problem, and if he can solve my problem, I'll pay him $10 million to solve it. So the way lawyers have addressed that is to just bring hordes of people at various hourly rates and throw it at that. That's what's changing and will change. Because Ralph will still get $10 million to solve that problem for me, because it's a $200 million problem. And if it's a $200 million problem to HP, I'm going to get the best person that I can get to solve that problem for $10 million. Now, when that changes and it's no longer hourly rate, big law isn't going to hire hordes of young people to do it, because it's not going to be in their economic sense to do that. They're going to hire good people, they're going to hire enough people, they're going to train people, but the whole model blows up the second you move away from hourly rate, because the way a senior partner makes a lot of money is leverage. And when the model changes, that leverage part goes away.
Right. What you just heard, this is exactly what's happening out there. It will affect your careers. All of you who are students, how many of you are currently law students? Right? So your world ahead, he just told you how it's going to be. And so he's not even now at HP. He's sitting here, free agent, free citizen. He's telling you, this is how it's going to be. HP and wherever Mike is next was not going to pay like they once did, even if the economy's booming. It's not going to matter. No one's going to do that, because people don't spend money they don't have to spend. They're willing to spend a lot, just not more than you ought to spend. The irony of this, without going too far, but the irony of this is, I think law is more important in commerce today than it's ever been. That doesn't mean that a profit-maximizing client is going to spend money it doesn't need to spend. Technology has enabled change. All sorts of other innovation has enabled change. So law is really important. And you're going, if you do choose this as a profession, you've chosen a really good profession for which there will be more and more demand throughout time. It's just that the nature of the demand and what it is you're called upon to do is going to be different. For the students who have self-selected and passed and made it through the application process for a school like this here at Stanford, this is all really good news, because it means the work that will be available for you is the really good stuff, the stuff that requires you to think, the stuff the technology can't do. So this is all good news, but it's a different answer than it was when we graduated from law school. The answer to, so what am I going to do, and how am I going to learn, and what do I need to do to prepare for it?
And on that point, I would say, in HP, one of the things that we always had to talk about was exactly the last point you made, Ralph. And I would always draw basically a triangle and say the stuff at the top at that point of the triangle is the most sophisticated, difficult stuff to do. And we have less of that. And then at the bottom is the basic stuff. And the reality is, when we cut that work out and shipped it offshore or automated it, and went to self-help for non-disclosure agreements for our business people, that was the bottom piece. And the truth is, did it mean less jobs? Sure, it meant less jobs to some degree. But the jobs that were there became a lot more interesting. And that's the challenge. I don't think there will be as many lawyer jobs on a constant basis. If you took a constant, a constant economy, I don't think there'll be more lawyer jobs 10 years from now. If the economy stayed the same, if the economy grows, then law jobs will grow with it. But at a constant basis, there won't be more. There'll be more interesting, and there'll be fewer less interesting ones, and that's going to impact the model of what happens to law schools. And I think Larry's right. I think some law schools are going to go away. Would be my guess, but that's a piece that I don't know that much about. But there are going to be fewer lawyer jobs by definition, because those things can now be done not by lawyers here in the United States. They can be done by software. They can be done by people overseas at dramatically lower rates. And interestingly, as I now go talk to people about being a GC somewhere else, they want to talk about two things. They want, as I get recruited, one is, how do you solve big problems, and and how do you stand up to management when you need to stand up to management and make sure you make the right decisions, and that's by far the first, and if it isn't, I don't want to go there. But that's the first. But the second is absolutely, and how do we do it economically? What's the model? HP seemed to, they're interested in, you hired out of law school, you were thinking different ways to do it. CEOs want to talk about that. Boards want to talk about it, because at the end of the day, none of the companies I'm talking to are in the business of running a law firm, unlike where Ralph is. They're in the business of selling whatever it is they're selling. And so they want to get this right at the lowest cost they can get. And they are pushing that cost conversation. When they push it with me, I'm going to go push it with Ralph.
Exactly.
And that's the way of the world. 15 years ago, general counsel didn't ask you those questions.
Exactly.
Now that's the first conversation, and it's getting more sophisticated. It used to be, just give me a lower hourly rate. Well, that doesn't do me any good if it comes to the same amount of money. At the end of the day,
Doesn't do us any good either.
yeah, at the end, yeah, that's right. But at the end of the day, what I want is an economic model, and that makes sense. And interestingly, I practiced criminal defense work after I left the Justice Department. Mostly big company work, but I took individual cases from time to time. If you wanted to compete for representing individual white-collar defendants, it's a flat fee case, because some guy basically says, I want to hire Ralph to get me out of trouble. But I'm not going to pay him an hourly rate for forever. I'm going to negotiate. You're going to pay me $1 million, and you're going to represent me through a trial and through an appeal. And the criminal practice of law has been that way for years, for 25 years at least. That it's not, it's
Well, actually,
very,
all law practice was that way through the 60s.
Right.
The billable hour is pretty recent.
But I think we should open it up to
Yeah.
questions,
Yeah.
because I'm sure there are people who have some. So come to the mic if you feel that you need a mic, otherwise just stand up and be recognized.
Hi, my name's Ron Dolan. Dean Kramer knows probably what my question is going to be. As we talk about technology, I wonder what the role of law schools is in teaching technology-savvy lawyers, and what we think about a field of legal informatics moving forward, so that we get more sophisticated technology from people that know law, not just engineering.
Well, you start with a really fundamental reality, which is that the students know more about technology than the faculty. This is a core problem in all American education. My 14-year-old, I don't mean this in any humorous way, that's where I turn when I have questions about technology. And so I think I don't know the answer to this question. I think it's very hard. It's not the core business of the law school to be technologists, and that's over in another few schools here, but it's really important. And we have only begun, just as is the case with most software, we've only begun to tap into what technology can do in law. It's still largely sorting and filing and so on. And one of the big challenges for us in the law firm is breaking through and doing things that are truly innovative and creative with technology to drive efficiency up and cost down. But I don't know what the answer is.
Well, one of the things that experts on legal education will say is if they're predicting where the market is moving in terms of needed skills in the future, it is with lawyers who are much more technologically savvy and who know how to develop those innovative products. And one advantage to schools like Stanford is the potential for cooperating with engineers and people who do software development at a very high level in a university setting to try to give our students those skills. And I think that's one of the areas that you're going to see increasing growth, because a lot of what's now being sold is being sold as a software product that has legal applications, and law schools have been late to the party in developing people who can tap into that market. And I think that's, most experts think that's going to change. So I think that's a really good question. And certainly places like Stanford will, I think, have the potential to do it more effectively than other schools. Other questions?
There's just one other thing on technology. This raises another issue that one of the trends that's changing law is an idea I like to call disaggregating. There's an author, Richard Susskind, calls it decomposing, which doesn't sound as good, but disaggregating complicated undertakings in the practice of law into its constituent parts, some of which are not complicated, many of which are not. And many of those not complicated constituent parts can be done by people who aren't lawyers at all. In fact, they can be done by technology. And you have to sort of disaggregate, and then you can find your way using pretty simple technology to address this. But there's a lot more to come. And I think the idea of connecting up with the great technology creativity here would be a good one.
Well, let me just say, because Ron and I were talking about this actually just this morning. So we have first already started this at Stanford. We actually have a center that's designed for just that. And again, Ron was talking about something pretty specific, right, which is somebody has to develop the products, and it actually can't just be done in engineering schools. It's, if anything, more law schools, and we need to bring those resources here because you need to know and understand the law to figure out both what the things are that are needed and how to make them work. When, I mean, what's interesting again is how do you grow an industry from scratch? And you saw part of it though, which is the industry itself needs education, that is, say, outside the law school, but the profession needs to understand what the real opportunities might be in order to begin growing it. I mentioned one. I went to Westlaw and Lexis to see if we could interest them in helping us build this, and it just went right past them, right? There's no sense of what the opportunities are, and that only in a university, and particularly one that has a combination of a great law and engineering school, can you begin to do that kind of stuff.
And I think, as appropriate for a discussion in Silicon Valley, entrepreneurs will do it. Where you're seeing it happen is lawyers who have the legal training, who leave the practice because they have an entrepreneurial spirit, but they have that legal background, they have that legal education, and then they pull it together with technologists, because you do have the conversation with law firms, they're not built that way, and to do that, and they're not opposed to it. I don't share the view that a lot of my former, and probably again someday to be colleagues as GCs, have this antagonism view with law firms. That is not my view at all. I think that they're optimizing within the model that is created, and somebody else is going to break through it. And it's happening. You see a company like Axiom is an example of where they're thinking about how do I bring technology and do exactly what Ralph just said. How do I take a problem, break it into component parts, and figure out what pieces of that can be done through technology, and then find the people in that business, bring them in and write the programs that are needed to go ahead and simplify.
It's going to be tough, though. I mean, all that's right, and this may be going deeper into this than we need to, but it's a really critical part of the change that needs to come. the economics of making the small changes, and then the change that you will experience will be the aggregate of a lot of small changes, aren't very great, and so it's hard to attract a lot of money into it. I'm not surprised that, I mean, both Thomson Reuters, those guys, they don't get this. Bloomberg just spent $1 billion buying B&A, and I had a conversation with them a week before last, and so far I don't think they get it either, but they get something when they spend $1 billion to buy content and try to make it more readily available with these desktop things they have. But it's going to take, I think, somebody like that who's willing to make a big bet on law as a profession to make the investment, because it's going to take big investment to get before you're going to get a return on the kinds of changes that really will change the profession.
Although again, I'm sorry, I just got, this is a really important question because, so again, some of it, you can't actually count on the entrepreneurs to do it, and that's because of a different change, right, which is the venture community is not what it used to be. And so there's a lot of basic background research and that requires large and longer term investments than you're going to get these days. So what you're talking about are things where people will take and think of innovative ways to use existing technology. But unlike some other fields like medical informatics, where actually medical schools have made major commitments and are generating all sorts of new stuff that can then be taken up in industry and used, we don't have anything like that happening yet in the law world, and there really is a lot of work to be done.
Okay.
Okay.
More questions. If we go on this long.
Just come down to the mic and.
What, somebody was standing there for a long time. We should take you first.
I just have a question, Kramer, about, I'm also very concerned.
You know, I'm really glad you asked that question, because if I had one to ask the panel, it would be, how are we going to break the political stalemate that we now have? I mean, Larry and I totally agree that you need to get out of the one-size-fits-all model, and especially if you're concerned about underserved communities. 80% of the legal needs of low-income people and a third of that of middle-income people aren't being met, even though, you know, we've got a job market that's filled with people who graduate from law school who can't get jobs at levels sufficient to pay off their loans. That suggests, you know, structurally the model is broken, and the ABA and its accreditation requirements has been, you know, the major impediment to innovation. And it's made it impossible for schools to radically alter the cost structure of legal education and still comply with those. And how are we going to change that? And I think it's, you know, there's got to be some pressure from leaders of the legal community, not just law schools, if we're going to try to get a different accreditation model.
Well, so there's two more obstacles there. So the ABA is the biggest one. The state bar associations, which are separate, are an additional one. So we now also deal with an additional overlay. I don't know how many noticed. We had a huge issue with all our LLM programs when the New York Bar Association decided, for reasons that are utterly beyond any of us, to impose a whole bunch of new requirements that limited our ability to create specialized programs and do things with the international students. And there's 50 separate bar organizations. And so you know, even if the ABA changes, but the New York Bar Association keeps it, you won't be able to practice law in New York, for instance, et cetera. And then the last, which is in some sense the biggest one, and limits our ability or anybody's to actually take a leadership role, is the antitrust laws, right? That is to say, we cannot work together. And so for law firms to work together to make changes, for law schools to work together to bring pressure to make changes is impossible. And so we're locked into, you know, a competitive environment, a hugely competitive environment, where the competition is destructive. Everybody recognizes it's destructive. In theory, a rule of reason analysis ought to give us a way around it, but you can't do it. So those are the major obstacles.
Well, there's another one. It was the basic economics of law practice. So when you reference the underserved, you're referencing the majority of people, the majority. Well, you said 80%. I mean, most people who need legal service are the underserved part. The people that are served well are Hewlett-Packard and similar by a small minority of the lawyers. That's why it's so important always in discussions of this kind to recognize that we're talking about preparing people for professions, most of which are not. I mean, maybe most of the Stanford graduates are going to big law, but most people graduating from law school are not going there. But it's very hard to run the economics of serving people, doing their wills and doing their day-to-day, what you need as a citizen in terms of legal support. And part of the reason is there's a prohibition against outside investment in law businesses. So you can't build a business on these low economics that serving the individuals generate. without, because there's no capital to do it. So that's why England changed its rules. But people sometimes think that the reason that the English firms now can sell equity interests in themselves was to make the Magic Circle firms rich. But it's not it at all. It was an order to create businesses that can deliver legal service in a way that's sustainable and affordable to the ordinary citizen. And I think in the U.S., until we get something like that, there's no way to make it work.
Yeah, well, and the bar has fought it tooth and nail. I mean,
They will.
The notion of Walmart delivering legal services is just.
Well, that's exactly the model. I mean, that really is the model. You can,
Right.
the same way you do your banking.
And one other part of it is you got to recognize.
And as you said, one of the other things you said that I thought was brilliant, and who were trained to spot problems, not solutions. And so there's a lot of problems in all these things.
Yeah. Another question.
Yes, I have a question.
No, you don't have to think of strictly anything, right? These are all nuanced, complicated questions. So the fundamental idea is this is a profession. And what does that mean? It means it's not all about the money. I mean, for starters, that there are standards that we will observe, whether they're written down or not, whether they're literal standards or they're in the penumbra, but we're a profession, and that's what we are. And the standards of our profession will guide what we do, and money will not be the be-all and end-all. Now, that said, there's still an economic reality. That's why it's very hard to build a law practice that's going to serve people who don't have any money to pay your fees. And that's why, if you're trying to serve Hewlett-Packard in the $200 million question, you can't do that out of your garage with a handful of first-year lawyers. So there's going to be a lot of expense required to enable you to do that. But it's critical to see that. You want to be a lawyer. You want to answer whatever you want to do, but answer the big questions, do all these things. And then there's some economic realities that surround it. Does that seem to reconcile those things?
Yeah, sure.
I don't think they're reconcilable. That is to say, we aspire to be a profession, but the problem is, for lots of the reasons we've been talking, we're locked into a business model, the decentralization of it all, and it's not money as much as prestige, I think, for most people. So once you're down the path of wanting to be at the most prestigious place, have the most prestigious cases, be recognized, you're off to the races, and then it's really hard to hold people back for these larger values.
I don't agree. I think that in fact, this is one of the reasons I said this at the beginning. You just got to set your mind to it. You are going to hold on to your values.
No, I understand, but most people don't.
Well,
it's the reality of the world is, and
right,
it
so
gets really, really difficult.
So one of the things that the Stanford Law School ought to do, and one of the things that Orrick should do, one of the things HP and your next, wherever you run next, ought to do is evangelize this, that this is a profession. And so when it comes down to this, is the way we talk about it at Orrick, when it comes down to this, the economics and the right thing to do are at odds. The right thing to do wins, always. In fact, if it weren't that way, the great law firms couldn't be global, because you'd have too much risk that people would be operating on in pure economic interest instead of in the interest of what's the right thing to do.
Can I interject one other question, Larry, since you brought up prestige? And one elephant in the room we haven't talked about is the U.S. News and World Report rankings. And if you ask legal educators what's the other cost driver for the current structure, it's not just the accreditation, it's that schools feel like they have to compete along the criteria that the U.S. News uses in rankings. And a lot of those are extremely costly. And in fact, an OMB report came out and said, they thought that it was the rankings more than the accreditation structure that accounted for the high expense of legal education. Of course, they were talking to legal educators about that. I'm not sure you get the same answer from everyone, but it does seem to me that that's another political obstacle to reform. And, folks in this room, I think, are critically aware of how important those rankings are in determining choices of students, and it costs money to compete on those.
So yes and no. I actually think that's much more complicated. First, there's not one answer. That I say that is the extent to which U.S. News drives anything is very different for different kinds of law schools, and the way it drives law schools is very different for different kinds of law schools. So, for instance, I actually don't think the rise in overall costs has much to do with U.S. News. Has much to do with U.S. News. That rise, to be honest, is much more a product of two other things. which the first of which is actually students want more and different kinds of services. So again, you compare the cost structure today to the 1980s. In the 1980s, you really did have a faculty of 35. That was all you needed, and a library. And you could run a really low-cost operation. Once you start building clinical programs, once you start building student organizations, once you start building a career services office, a student affairs, all of that apparatus, that's what drives cost. Now, what I think where U.S. News has been particularly bad, and this is, Deborah has an article coming out, which this point I think is absolutely right on, has been a dislocation, right? Because there are certain things that it drives some schools to and some more than others, right? Which is, so the key one would be you need your students to have like really good LSATs and really good GPAs, and that creates competition for the best students that has driven basically all law schools except for us, Harvard and Yale at this point, to shift a big chunk of their scholarship funding to merit, so-called merit scholarships, where they're just, and the ironic thing about it is, of course, there's a huge amount of money then gets shifted away from students with need to students without need, and the students end up at pretty much the same places because everybody's doing it, right, except for the top three. So I think there's those kinds of dislocations. And then the other thing about U.S. News, if you look at it, about the top 20 schools, there's almost no movement. And that's why it's not a big driver for us. I mean, we're worried a little at the margins, but we have never actually made a significant decision, and especially not a budget decision of any sort, by U.S. News. We just haven't had to. Once you move past the top 20, the swings are huge. And there, I think, if you go from the second tier to the fourth tier, that has massive effects on your school. So those schools have to worry, yeah. So it does have substantial effects down, farther down. But again, they're mostly distributional as opposed to overall costs, although there's some of those too because of the expenditure per student part.
Yeah.
I think I'm not a student of this issue for you. I am for law firms. And anytime you try to rank order these things in a list way, there's going to be problems. It's going to create problems. It's going to lead you to make the wrong decisions about what you do. In the American Lawyer magazine, they rank the law firms by profitability per partner.
Yeah.
And we've declined. We don't publish our data anymore. And I don't care if people think it's because we're no longer making a fortune. We are. But that's not the right way to measure law firms. And it was making us do stuff internally to prop up that number. And had other things. I think Morgan Lewis just recently took the same position. But lists, you can't rank something as complicated as law schools on some kind of list. And do you think this matters at all to the law firms? Do you think we care one whit where Stanford ends up ranking compared to Harvard and those guys? We have our own way of knowing this, and it's not going to be. How many of you rely on U.S. News and World Report as your principal source of news? Why would you rely on U.S. News and World Report to tell you where to go to law school? They're starting to rank. I mean, anyway, this is a silly idea.
All right, Stacy. Well,
Whose opinion?
yours and mine.
Whose? Yours?
Yours.
Anybody.
Oh, can I go first? So first, you have to come talk to me after because somebody gave you like really what I would regard as really stupid advice. Just so you know, and without knowing who it is, whoever it was, really stupid advice. Just not true. I mean, like emphatically so. I actually think also the notion about like people don't have practical experience at the elite law schools is also actually not true if you actually look at who's hired. Now, what is true, and this is because there is the production of scholarship as part of what we do, is to me, what a lawyer does and what an academic does are in some sense the opposite. The function of being a lawyer is to take something that is really complicated, and especially a litigator, try and make it seem simple. And the function of being an academic is to take something that people may think is really simple and try and show how complicated it is. And if you enter this after 10, 20, 30 years of doing either one, that change turns out to be really, really difficult to make, and very few people make it successfully. So people who've been academics for 20 years make crappy lawyers when they make the move, and it's true in reverse. So what we typically do is we get people who have 4, 5, 6 years of experience, and then they come into teaching. And of course, what happens over the course of their career is the relevance of that practical experience in their teaching and scholarship fades as it gets more and more distant, although most of our faculty remain engaged in the practice. Like I consulted my entire time in teaching, do 4 or 5 cases a year, typically over the course of a year, just to keep a sense of it. And I think all those things are much more true for faculty. So people who want to caricature this, look how many JD PhDs they have without looking what did the PhDs do actually before they went into teaching, because I don't think we have any who didn't spend at least a few years in practice, maybe one.
Oops.
Who? How many do we have? You?
Yeah, I didn't.
That was back in the early 70s.
Right, well, late 70s, but in my defense,
Late
and
70s.
here's the important thing, Stacy, I was very conscious of that when I came in. So first thing I did was I volunteered, with the ACLU project, and I got involved in litigating an abortion case. And since then, I think I have probably much more involvement with real world, through consulting, through being an expert witness. Last week, I was representing a client getting a domestic violence restraining order because I thought, I really want to see how the court works. And it's been a long time since I've had a real client. So I think it's not whether you put in your obligatory 3 years in practice before you came in to the law school, which is how people measure whether you, quote, had practical experience, but how engaged you are with people in the real world once you get out. And do you study? Do you do empirical research? Are you talking to lawyers? I spend a lot of time interviewing lawyers for various projects. So I think that's much more important than what people did at the end of their career. And I can name you lots of my colleagues who feel like, once they hung their shingle up and moved in, they don't have to do this anymore. And they're not particularly supportive of clinical education or practice-oriented and problem-oriented approaches and innovative models in the classroom. It's not what you do at the front end that determines how good you're going to be in having an understanding of the real world and communicating its importance to students.
And one other thing, which is, comes back to something I said before, and it's going to actually give me, now I'm going to get really critical of you guys, right? Which is what I said before, which is the law school and your time here does not consist, and if it does, you're making a mistake, of the full-time tenure track faculty. They have a role to play here. Right? Part of the role is the introductory, theoretical overview, understanding the structure of a law course, and they're phenomenal at that. And spending more time in practice would not make them better at that. If you spend your 3 years taking nothing but those classes, then you're going to miss something. But if you look at what's available to you at the law school, in fact, right, the kinds of experiences and exposures you want are broadly available in the faculty with all the other people who are teaching classes here, and that should be part of a well-rounded curriculum.
On that evangelical note, I think we ought to close the panel and invite people to come and talk to the panelists informally after this session. So thank you so much for listening.